This is Talk Business and Politics with Roby Brock.
Welcome to the program. Joining me now, John Brummett, columnist with the Arkansas Democrat-Gazette. John, happy Juneteenth to you. Happy Monday to you. And it is good to see you as always.
Same. Happy day, happy week. Good to see you.
Late last week, I believe on Thursday morning, the Arkansas Supreme Court in a 5-2 ruling did not make us wait until Friday after hours to learn of their decision to lift the temporary restraining order on the LEARNS Act, which had been in place, and they had actually kept in place a week or two earlier. What's the end result of this? There's been a lot of backslapping and congratulations on this part of this LEARNS supporters, but the court did not rule on the merits of the case.
And you want me to speculate insightfully on how this is all going to turn out? Is that what I hear you asking me?
We'll eventually get to that. I want you to kind of talk a little bit about the lifting of the order. What was the logic in lifting the order, and maybe set the stage for where this goes next.
Okay, the lifting of the order by Supreme Court by a vote of 5-2, which replaced a vote of 4-3 to continue it the week before, was based on 3 votes from 3 I call the most Republican justices who had been against it from the beginning, and in who their written opinions indicate they think there's no merit to this case. Courtney Goodson, Hudson, who wrote the opinion, opined for the majority of 5 that to have a temporary restraining order, you have to have a demonstrated case of irreparable harm if you don't impose the temporary order. She said none existed here. A 5th justice, Karen Baker, who happens to be running for Supreme Court, flipped on this matter, and for her part, said our ruling on sovereign immunity of the state can't be sued in her own courts invalidates this thing anyway, what she seemed to say to me. So that's what happened. Nonetheless, on Tuesday, it goes back to the circuit judge who made the original temporary restraining order, gave that original order for a permanent adjudication at the circuit court level. He's liable to to rule in favor of the plaintiffs. It goes back to the Supreme Court. That's where we are. So you got the governor's side and the Republicans and the legislators claiming what they seem to be thinking is a permanent victory. You have the other side talking of a setback with litigation yet to go. Meantime, I've got a friend who asked me over the weekend, is this LEARNS lawsuit about the emergency clause either way going to amount to much in the long run? That's a good issue because, there's at most, a victory just delays the effective date. And there are a lot of other things at play that would be affected only a little by that changed date, I think, in terms of getting petitions to get this thing referred, in terms of the Elaine Marble School District finding some other option when none appear to be available. So that's my best synopsis of where we are, how we have got here, but not how it's going to end.
Yes.
Which I can gladly speculate on if you'd like me to.
Well, let's gladly speculate on that. How do you think this plays out?
Well, if you were listening to me closely and not bleary-eyed by all this legal process, I said 3 most Republican justices seem to have indicated they don't believe there's a case here, that the legislature sets its own rules. So there's 3 votes out of 7. And I think I just told you Karen Baker in her TRO ruling last week, her concurrence cited sovereign immunity. The state can't be sued this way in her own courts. How many is 3 plus 1? That's 4. How many justices are there? 7. So I think odds are that no matter what Judge Herb Wright rules at the circuit court level, and I think he may rule in favor of the plaintiffs, I'm pessimistic, shall we say, as one who'd like to see this law messed with any way they could, that it would prevail at the Supreme Court. I think 4 justices, to me, have signaled their hand. And if I'm right, one of the more interesting things is going to be that the Supreme Court will be saying, the state constitution means what it says when it said the state can't be sued in her own courts. But it doesn't mean what it says when it says there must be separate votes on an emergency clause. But you know, the Constitution also says the legislature sets its rules. The fact is, no constitution, no document is perfect, and we live by flying by the seat of our pants to interpret disputes under the Constitution, and all we got is a Supreme Court at the state level and at the national level to decide that interpretation at the time. So, and we have to abide by it. If you don't abide by it, you end up like Donald Trump trying to stay president when you lost, and he didn't prevail at that. So, I mean, that's how I see all of this unfolding.
All right, good analysis there. I think Tuesday's hearing in Judge Wright's court, I'll be anxious to see how quickly he rules on something, because that will determine how quickly it gets appealed and how quickly the Supreme Court may weigh in on this matter.
By the way, signaling things, he said in his TRO, separate votes and separate and same do not mean the same thing. He said that. And to grant a temporary restraining order, you have to assert a likelihood of prevailing in the end. So he's quite as certain as near certain as I am about what the Supreme Court would do. It seems pretty certain what he's going to do. We'll see if any of that is borne out. Yeah.
All right. You had a column on Sunday that talked about. Well, I'm going to let you give the synopsis of it here, but it talked about the Southern Poverty Law Center. It's dubbing of Moms for Free or Moms for Liberty as a hate group. Secretary of Education Jacob Oliva going to speak to that group. Yet there's even more controversy than just him speaking to that group. There's controversy about whether or not Moms for Liberty is even a hate group from some of the feedback I've gotten from our article on that, much less your column. So let's frame up that debate a little bit, kind of as you see it. What is, how does this frame up the conversation for us?
I'm going to give you a macro view about this. I think the big picture, and I think it's big, but it may be obvious to a lot of people, a lot of other people, and I may be just the old guy just finally figuring it out. But we have redefined extremism in our society, and extremism ain't what it used to be. And the simple fact is, whether right or wrong, in the 60s and 70s, the high moral ground tended to the left to fight bigotry and hatred and violence toward Black people, toward Jewish people. And the Southern Poverty Law Center was this beacon of progress, trying to fight such groups as the Ku Klux Klan and other white separatist groups and those sorts of things. Now, there is not as much universal galvanizing against people such as Moms for Liberty who organize because they oppose some of the things they hear their kids are learning in school, and they don't want what they see as advocacy for transgender bathroom use and those sorts of things. And I don't think it's as compelling in terms of universal political positioning as the progressive view was in the 60s or 70s. In fact, what you hear now from Arkansas legislators is the hate group here or the extremist group. I think there's a difference between extremist group is Southern Poverty Law Center itself. They're extreme in their hatred of those of us who have our church-based values on these culture issues. I believe it's completely turned around. I think it turned around before I realized it. I think it's long been coming before I saw it coming, but I ought to see it coming because Sarah Sanders in that sort of formulation only got what, 63% of the vote. So I think just doesn't mean. There was a time when it was, whoa, what a big headline. Moms for Liberty has been added to a list of extremist groups. Now it's not a big deal. Not only is our education director going up there to talk, but the two leading candidates for the Republican President, Donald Trump and DeSantis, are on the agenda. And as I put in the column, but they're using to define Moms for Liberty as an extremist group, you could almost say that they could use that reasoning and call the Arkansas General Assembly an extremist group. So the bigger picture here is that our Republicans have become more rightward and to blend with what used to be extreme, and the left wing is advancing moral ground that is not as compelling as racism. That's sort of where we are. Seems to me.
It's interesting. Our politics change, and just
We're
took a
supposed to
couple
change
decades
with it,
for all of this to change before our eyes here. So,
It does. All right.
all right. He's John Brummett, columnist with the Arkansas Democrat Gazette. Thanks for sharing your thoughts. Appreciate you.
Okay, buddy. Next time. Bye-bye.